All right, good morning again, everyone. It's really terrific to see you all here. It's particularly gratifying because I'm a new member of the faculty, which is to say you have no idea who I am. I just got here from UCLA. This is my first time actually teaching. And I have to say, I'm still in the mode of transitioning. And indeed, if you had the opportunity to go into my office, you would know exactly what I mean. And I think my apartment would put that point into even sharper relief. So thank you very much for coming. I want to thank you as well for just staying engaged with the school. I mean, you already understand, given the particular moment for your class reunion, that your voices have shaped this law school in profound and important ways. So one of the reasons these events are critical is because it reminds us of that. So welcome home. So the title of my presentation is Undocumented Criminal Procedure. And the argument I mean to make is simply this. There are a bunch of cases at the intersection of Fourth Amendment and immigration enforcement that exist kind of on the periphery of scholarly attention on the one hand, on the borders of scholarly attention, you might say. And on the other hand, they're doing really, one more time, really important doctrinal work in the interior of the doctrine. So the story I want to tell then is about how immigrant enforcement cases are actually shaping doctrine in the mainstream of criminal procedure. That's the basic story. And in order to tell that story, I want to step back a little bit and provide a frame for thinking about policing generally and race and policing more particularly, a frame that I call the structural frame. Now, much of what I will say appears in this book, Unreasonable Black Lives, Police Power on the Fourth Amendment. You should buy it, you know nothing about it, but go and buy it, even though anyway, there you go. So look, the presentation will unfold in 4 acts. The first 3 acts will be about thinking through problems of race and policing structurally. And the 4th act will get pretty granular with respect to the doctrine. So let's start at the very beginning. It's a very good place to start. You know this reference, yes? What is the reference? Sound of Music. My students don't always know this reference. The one of them is in the back. But it's the Sound of Music. So when you're singing, it's... Say it. When you're singing, do, re, mi. You said you know the reference. When you're counting,
1, 2, 3.
Alphabet. Thinking about policing structurally. All right, so there you go. So I want to think structurally about policing. And the difficulty with respect to thinking structurally about policing, it seems to me, is that engagements around structure are something of a conversation stopper. One doesn't go to a dinner party and say something like, hello, everyone, I want to talk about structure. That's the easiest way to shut people down. So on the one hand, I'm saying it might be important for us to think about structure. And on the other hand, I'm saying it can be a conversation stopper. So we will enlist the help of Tina Turner and begin things nice and easy. So we'll roll down the river, if you like, to a place that I want to call Green Valley Farm. So the conceit is this. This is not Old MacDonald's farm, to be sure, but on this farm there are some horses, E-I-E-I-A. So the horses are sick. Stipulate that the horses are sick. And the question is, well, why are the horses sick? And if we had time, we'd have a conversation about it. And typically the responses that I get go in 2 directions. So the horses are sick because the horses are not drinking enough water, let's say. The horses are not eating enough hay. The horses are not pulling themselves up by the bootstraps. So it's a story fundamentally about the horses, what the horses are doing to themselves or failing to do for themselves. Another set of responses tend to focus on the farmer. So the horses are sick because of something the farmer is doing to the horses or something the farmer is failing to do for them. The farmer might prefer the chickens. Indeed, we might call the farmer a horsist, analogous to a racist or a sexist. You get the basic idea. But if we pull back the frame, we begin to see that the horses exist in a toxic environment. To put that another way, the horses are going to be sick. So quite apart from what the farmer is or isn't doing to the horses, and quite apart from what the horses may or may not be doing for themselves, they're going to be sick because they exist in a toxic environment. Now, we could intervene by asking our horses to put on a mask. I don't mean to politicize the conversation. We could do that. The horses look better in masks than we do, I have to say. Or we could focus on the farmer. We could say, listen, farmer, why don't you listen to the stories the horses are telling about their marginality? Just listen to them, even if you must do it over Zoom. We could do that. I don't mean to poo-poo either of those interventions. They're not trivial, but we could take a more structured approach. We could say, let's endeavor to clean up the environment to remove the threat. And if we engaged in that particular kind of intervention, presumably we would not say that is an animal preference for horses. I don't know anyone who would put the intervention in those terms. We would say, presumably, that it's a necessary intervention that helps to clean up the environment so it looks like this. And if it looks like this, it's a good environment, not just for the horses, but presumably for everyone else. So that's kind of the nice and easy. The nice and easy is that we transcend two frames. We don't just focus questions on whether there's something problematic about the farmer. We don't just focus on whether there's something that the horses are not doing for themselves. Instead, we step back and we think big. We think, again, structurally. Act 2. The question is whether we can make something like that move in the context of policing. And what I want to suggest is that we can. And our starting point for making that move is to move beyond conversations about whether officers are good or bad. I don't find those particular conversations useful. And indeed, they lead to unproductive arguments that demonize cops as individuals. Don't think that's particularly helpful. So I think instead, again, that we should step back, just as we did with respect to thinking about the horses, and ask structural kinds of questions. So one way to think about this structurally, and this is just one heuristic device, is to ask questions about whether each of these dimensions of this diagram help to tell a story that transcends individual cops. So we might begin with the first two moves. The first two moves are simply saying that repeated police interactions expose people to the possibility of violence. Nothing about good or bad cops. So if you're not having contact with the police, presumably you will not experience harm by the police. So a significant question that one might need to think about then is, what are some of the social forces that stage contact between people and the police? And there's an awful lot we could say about that, but I won't. Instead, I'll move to the next cluster of concerns. So here we might be thinking about police unions. Here we might be thinking about police culture, organizational culture. Here we might be thinking about police trainings. We're not talking about individual cops. We're talking about a cluster of concerns that play a role shaping police behavior on the ground. Well, we might ask a slightly different question. So now we're thinking about police violence and the fact that it has indeed occurred. And the question is, how does that violence interact with the legal system? To put that question another way, police violence plus the legal system equal what kind of outputs? So one output is justifiable force. We're stipulating that violence has occurred, it enters the legal system, and it comes out as justifiable force. We could articulate that claim with slightly more specificity. So we could invoke, for example, a prosecutor's decision not to bring charges. That's a moment in which we have police violence plus the legal system equals justifiable force. We could think about grand jury indictments or non-indictments, where the prosecutor says, let's bring a charge, and the grand jury chooses not to indict. That is another moment in which you have police violence plus the legal system equals justifiable force. Or we could have a prosecutor bringing charges, grand jury indicting, and a trier of fact says it's all reasonable. So each of these moments are ones in which no dispute about the violence, it enters the legal system, and it comes out in a particular kind of way. We could talk about qualified immunity and indemnification. I don't want to get into a conversation about qualified immunity because you'll be saying, come back, Devon, and I won't be able to come back. But the point with respect to qualified immunity, I think you all understand this, is that it erects a pretty high bar for holding police officers accountable when they engage in acts of violence. There's not much of a dispute about that. The dispute is about whether or not it's appropriate to have the right bar, but across the ideological spectrum, people descriptively agree with the idea that qualified immunity erects a high bar. And then there's indemnification. So to the extent that one manages to jump that hurdle, if you like, jump that high bar, then police officers don't pay. Cities and municipalities do. And finally, the non-departmental liability point. It's enormously difficult, I think you will appreciate, to hold police departments liable for the acts of violence in which their officers engage. So the reason I'm telling this story is because it helps us see a standard incentive around organizational behavior. So if at the front end of policing, one knows that at the back end, there's justifiable force, there's qualified immunity, and there's department non-liability, it creates a disincentive to exercise care with respect to when and how force is mobilized. This is not about a good or bad cop. We could spend an enormous amount of time unpacking each of these dynamics and not mention the word bad cop. So I'm trying to suggest then that this is just one way to think about the problem of policing structurally. There's another way. We can go slightly more granularly, it seems to me, and now ask a more particular question, still at the level of structure, about police power. And we can make the point more particularly still by disaggregating out police power into its constitutive parts. So these are just some of the axes along which police power comes into being. And the point that I need to emphasize here, I think is an important one, which is police officers are not born police officers. I'm hoping that's not a radical claim. Police officers become police officers, and they become police officers through their access to and deployment of particular kinds of power, including these ones. There's another way to demonstrate this particular point. That's your police officer made up of powers. Police officers are the embodiment of powers, it seems to me. And if we understand the point that way, then we can think about particular kinds of debates about policing. Presumably you were familiar with debates about policing that have to do with, for example, abolition. And the idea is, should we make something like this move, where police officers are gone? People have a hard time getting their head around that particular idea for good reason. It's hard. It's not easy to imagine a domain within which police officers are not present. But you could make a move that's slightly more granular and ask about police power abolition. So we're saying, should we get rid of qualified immunity? Should we abolish it? Should we get rid of no-knock warrants? Should we abolish it? We're not going to agree on every dimension of this particular question, but everyone can enter this debate. It's a legible debate. It's an understandable debate. So even if you're like, I don't know what to do with the debate about police abolition articulated at that level of abstraction, I just can't get my head around it. If I particularize the inquiry and say, look, we're thinking about police officers as embodiments of power, so let's ask ourselves which one of these powers we think are particularly troubling and have the conversation that way. The broader point I'm making is that this inquiry about police embodiment vis-a-vis power is a structural one, not about an individual bad cop. Good and bad cops have this power alike. And this broader schematic still is, again, about police officers and police problems in a structural frame. It's not about that. Okay. Let's make another move to Act 3. So this time I want to think about cognitive structures. And it invites us to ask questions about, so how do we think about cognitive structures vis-a-vis biases? All heard the term implicit bias, presumably. I don't know to what extent you're familiar with some of the literature on which it rests. So this will be a quick primer of some of that. For obvious reasons, it is implicated in the domain of policing. And indeed, I'll introduce a study that's relevant to that point. Now, in order for me to say more about this, I need your participation. This is a task that you can perform because you are NYU grads. Now, I just need to feel that you're awake. So look, here's what I need you to do. You just shout out those colors. Shout them out. You are not awake. Okay, I see. Shout out quickly. Again, one more time. Blue, red, green, black. Okay, so I've given you the answer. I don't do that with my students vis-a-vis their exams. So I've given you the answer. Blue, green, red, black. I'm going to take them away, and we're going to do it again. So all I want you to do is just focus on the colors and shout them out as loudly as you can. On your marks. Are we ready? All right, go.
Blue, red, green, black.
White,
Green, red, black. Red, green, black.
Okay. Some of you kind of got through it, but most of you, even if I curved this class, you didn't do particularly well, I have to say. The baseline is just not particularly good. So tell me why that's the case. Or to put it another way, let's ask the Marvin Gaye question. What's going on? 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 Someone tell me what's going on.
The color and the words are mismatched.
The color and the words are sometimes mismatched. So when they're not mismatched, it is easy.
Nice and easy.
Right, nice and easy to take us back to Tina Turner. And when they're mismatched, it's hard. Something like that insight underwrites the implicit association test. So here's what I mean. So if we think about these faces, for example, identifying black as good, everyone can surely do that. Right? You can do it. It's not like you can't do it. But it's like identifying the color red in the word green. If you slow down, you can do it. Black is bad. That's easier. That's green and green. White is good. Green and green. White is bad. That's the basic idea. Implicit bias measures our reaction time, and it's really important to emphasize that point. Much of the implicit bias literature rests on a delta. So we call that delta implicit bias, which means that you should ask, is there a causal relationship between that delta and real world behavior? No. Sometimes people put that point too strong. There is no causal relationship. There are some correlations that suggest that we should be worried, but there's no causality. So one can overstate the phenomenon of implicit bias, which people sometimes do, but we can also understate it and not recognize that the science on which it rests is suggestive of a relationship that we ought to therefore take seriously. So 2 studies. One study involves real lawyers in real law firms, and it implicates NYU. Now, this particular study was not peer-reviewed, so I really want to emphasize that point, and I'll get to a study that tells the same basic story. But here's what's happening here. So 60 law firm partners were sent identical memos from a Thomas Meyer, all right? So one of the Thomas Meyers, they're led to believe is black, and the other they're led to believe is white. And the way this happening is the memos under the name indicates the racial identity. So, lawyers get accused of being sneaky. Trust me, social psychologists, super sneaky, right? They sneak things in all the time. So they sneak that in. And so here's the deal. NYU grad, third year associate, the memos embed big arrows, small arrows, and as I said, race is revealed below the name. So the memos are evaluated on quantitative terms and qualitative terms. So they're given a numerical score. So here are the ratings. It's the same memo. It's exactly the same memo. So ratings 4.1 versus 3.2, arrows 2.9 out of 5.8. Now, I doubt any one of the partners reading the memo, let's get the black guy. Chances are that's not what's going on. Something else is presumably happening in this space. And then if we look at the qualitative stuff, generally good writer, needs to work on, has potential, good analytical skills, average at best, needs work, can't believe what's NYU. So we see this, again, surfacing at both levels. And again, one would be hard-pressed to say that these are moments in which the partner is thinking, I'm gonna just privilege the white person, and just, that's chances are not going on. So here's another study. This study is not based on a reaction time delta. This study is based on a particular priming technique. One of my co-authors conducted this particular study. It's a classic study that has been enormously important in the literature. So what happens here is the researchers are trying to figure out, can we empirically demonstrate a nexus between blackness and crime and blackness? And in order to answer that question, the experimenters did this. They primed people with black male faces or white male faces, or people weren't primed at all. So you sit in front of a computer screen and you do not know that you've been exposed to an image because the images pop in and out too quickly for you to realize that you actually saw them, right? So that's the way the priming works. And then the participants are asked to identify particular objects. And there are two kinds of objects about which we're concerned. So there's a crime-relevant object, like a gun or a handcuff, and a crime-irrelevant object like an iron, right? So those are the objects about which we're concerned. And the problem for the participants is that the objects appear before them at different levels of degradability. So if I show you this image now at frame 1, you probably can't figure out what it is. At frame 25, maybe you can kind of see that's a gun, and at frame 41, you can see it's a gun. So the question becomes, to what extent does a particular prime, being exposed to a prime, shape the frame at which you see the objects? Does being exposed to the prime mediate when you see the gun, mediate when you see the iron? So here's the results. So we open the curtains and we focus on the first crime irrelevant object. So this is the data for the frame at which the participants saw the iron, right? So you see across the three conditions, the conditions, the flashing white face, the no face, and the flashing black face. So the question is, all right, what do we make of that? What we make of that is that being exposed to the iron doesn't really affect the frame at which you see it. Everyone sees the iron at roughly the same frame. So there's no statistical differences among and between these conditions. Being exposed to the iron, again, does not shape the frame at which you see stuff. If we change it up and focus now on the prime that was the blackface, we see something quite different, presumably, right? So now we're looking at these bars. So what's the story? What's the story? This is the story, again, when you've been exposed to the gun, that's the prime, or the handcuff, across these three conditions. It doesn't add up, but how? What's the story that it tells?
It demonstrates the bias.
It demonstrates the bias, and we can be more precise about it still.
Everything's more relevant when there's less, when it's going up.
Everything's more. So how do you put that point? Again, I'm going to keep pressing, like I do when I annoy my students. Yeah.
Being exposed to the black faces means you recognize the crime-relevant image at a lower frame rate.
That's precisely what's going on. So if you've been exposed to the black prime, it's a gun, I can see it. If you've been exposed to the white prime, it's not a gun, it's not a gun, it's not a gun, it's not a gun. Okay, finally, it's a gun. And you can think. And significantly, this particular study included police officers. Okay? So again, this is not about conscious thought necessarily. I was at the New York Judicial Conference yesterday, I did the talk there, and a social psychologist from Howard gave a presentation in which he says, look, do you know what explains implicit bias? you have a brain, and you live in the world. Which is to say, we're consuming stuff all the time in different kinds of ways, and we all know that to consume stuff is to reproduce it in our head. And so this is effectively telling the story of consumption around racial ideas. There's another set of studies that are really interesting because these studies are designed to ask, to what extent do we associate black people with weapons to a greater extent than we associate white people with weapons? And again, consistent with these findings, we associate black people with weapons to a greater extent than we associate white people with weapons. What's shocking about this study is that the weapons that are the predicate for this particular experiment look like this. What do black people have to do with this? I kid you not. Or this. And this. So the point then, it's not an empirical question about, whether black people have guns like that, the Englishman's handgun. It's about whether these are signifiers of violence and whether we associate people with violence, and that's the connection. So again, this is just one strand of research that invites us to think about cognitive structures that do a particular kind of work that's clearly relevant to how we think about policing and race, particularly given what I said at the outset, that we're concerned with the degree to which having contact creates exposure risk, and biases can facilitate precisely those contacts. I would be remiss, again, not to say, can we trust the science? Short answer, yes. Carefully. By that I mean, people, as I said before, overstate sometimes the empirical foundation of the science in ways that we should worry us. But we shouldn't throw it away. We shouldn't say there's nothing there. There's just mountains of evidence that go in the same direction to suggest that these things exist, and they transcend race and impact other identity categories as well. All right, so let's now move to doctrine. So to move to doctrine is to begin with the text of the Fourth Amendment, which, as you know, protects us from unreasonable searches and seizures. That's what the Fourth Amendment does. So that textual language means that in order to answer Fourth Amendment questions, we must ask ourselves two fundamental questions. Question one, do we have a search or seizure to begin with? Because if we don't have a search or seizure, the Fourth Amendment does not kick in. It protects us against searches and seizures. So we need a search or seizure for the Fourth Amendment to do work. If what the officer does is neither a search nor a seizure, then what the officer does resides beyond the regulatory reach of the Fourth Amendment. So we need to make an argument that we're in the game, in the Fourth Amendment, and that argument has to be that there's a search or seizure. That's movement one. The fact that there's a search or seizure doesn't mean that the government has done anything wrong. The Fourth Amendment doesn't protect us from searches and seizures. It protects us from unreasonable ones. So if we're stipulating now that what's happened is a search or seizure, then we move to the domain of unreasonableness. Yes, everyone get that? Do not say yes if you don't, because a test is coming up. You didn't do very well on the first test. So are we good to go with this test?
Yes.
Yes? All right. So I'm going to take you back in time to 1968. That should be 1968, not 86. In 1968, I could ask you what your favorite movie was. I'm not going to ask you what you were doing. That's going to reveal questions about age and all that stuff, and I won't get into it. So look, here's the thing. We have the government, we have the defendant, and we have the Supreme Court as a legal actor. The case involves stops and frisk, as you know. I suggested that with respect to Fourth Amendment jurisprudence, we have to be in the game. Being in the game means that we need to make an argument that there's a search or seizure to begin with, and then we need to sort out what kind of evidentiary showing will justify it. Yes? So you're going to shout out again, and you're going to get it right because you said you're going to get it right. You're the government in the context of this case. Okay? You're the government. You ready? So the question is, from your perspective, Is a frisk a search? Yes or no? Shout out.
No.
No. All right. So a frisk is not a search. Is a stop a seizure?
No.
What evidence you showing?
No.
Nothing. You were less confident with the nothing, but you were still there. You want to say this stuff resides outside of the regulatory reach of the Fourth Amendment. It isn't implicated, and the way you do that is to say it's not a search, it's not a seizure. Yes?
Yeah.
All right. So
I
now,
disagree. I think it is a search.
now we're getting what we're saying. If you're the government, this is the argument you make. Yes? If you're the government, you're saying it's not a search, it's not a seizure. All right? Yes? You're not quarreling with that. All right, good. Because then I would say, do not represent the government if you're quarreling. All right, so now the defendant. So is a frisk a search?
Yes.
Is it a search? Is it a stop a seizure?
Yes.
What evidence you showing? Be more aggressive? Be more aggressive. Is that the best you can do in the Fourth Amendment? What else is there? What could you require? Sorry? Okay, you could say a warrant. That's being ridiculously but I just wanted to see if you were alive. So not a warrant, not what do you need to justify it? I mean, so it's probable cause. What justification? We have different evidentiary standards in the Fourth Amendment. The gold standard is probable cause. That's what you need to shore up a warrant. So that's what you would presumably argue for here. Justice Warren splits the baby in some sense and says reasonable suspicion, right? So things are more complicated than this, and we'll get to that complication, but this is our point of departure into the doctrine, into a story about undocumented criminal procedure. So well done. You got your A back from your, I won't even assign a grade to the Stroop test. So let's think about the first undocumented case that I want to put on the table. So the first undocumented case is INS versus Delgado, and this one was litigated in 1986. And so here's what's going on in this case. You have what the court refers to as a factory survey, which is to say an INS raid. So INS is entering these workplaces, not unlike scenes with which we're now familiar with in the contemporary moment, and they're running about the workplace, questioning people. They're stationed at exits. They are arresting some people at these exits. And the court is presented with the question, is this a Fourth Amendment moment? In other words, is this a moment in which we're going to say the entire workplace is seized? Is this a moment in which we're going to say individual people who are engaged are seized? And to answer that question, the court tells us that the doctrinal test for a seizure is whether you feel free to leave. The court concludes that under these conditions, people are free to leave. People are not seized. That's the move the court makes. Now, there are lots of moments in constitutional criminal procedure where I have a view about something, and I'm like, okay, I kind of get that. I disagree with it, but I get it. This is not one of those moments. It's just like unbelievable that the court thinks that this encounter is one in which people feel like, okay, I'm just going to go about their business, particularly because people were actually arrested. Right? That's part one. The second point I want to make is that Justice Powell, in his concurrence in this opinion, says, look, let's call this a seizure. Let's not be silly about it. But let's say it's okay, even though the government has no suspicion with respect to anyone, because this is immigration enforcement. And the government has a particular kind of regulatory authority in that domain. His argument doesn't carry the day, but it gives you a sense of how plenary power immigration concerns are operating in the background of these kinds of cases. So we leave this case then with an understanding that it's a moment in which the court is saying, oh, you can question people about whatever, and they're not seized. That's the undocumented case that we don't take seriously enough in the literature. Enter a documented case, Florida v. Bostic. Every law school class teaches this particular case. It's a case that takes place on a bus So Bostic is sitting at the back of the bus. Officers see him sitting at the back of the bus. Again, just like in Inez v. Delgado, they have no reason to believe he's done anything wrong. So precisely because they have no evidentiary predicate, they have no reason to think he's done anything wrong, they want to make an argument that it's not a seizure. Because if it's a seizure, the government loses. So they approach Bostic without any reason to think he's done anything wrong. They ask him for permission to search. There's some dispute about whether he says yes or no. They get in the bag. They find evidence. Bostic wants to say, suppress the evidence. It's an unreasonable seizure. You're stipulating you didn't have any reason to think I did anything wrong, A, and you seized me, B. Justice O'Connor is writing the opinion. She doesn't ultimately decide this seizure question directly. She remands it for reasons I won't get into. But she makes absolutely clear that this is not a seizure. Why is this relevant to our discussion about the undocumented case? It's relevant to our discussion in two ways. First, Justice O'Connor says, see INS v. Delgado. Just as the people in that case felt constrained because they were at work, the fact that you can feel constrained that you're on the bus, Bostic, so what? You need to tell me that the officers actually did something that effectuated that constraint. The fact that you're physically on the bus and I'm constrained, I can't get off, the bus is going to take off, my luggage is there, etc. None of those arguments matter. Just as the workplace might have constrained the workers' movement, your place on the bus constrained yours. That's not about police conduct. Second, the court modifies the doctrine so it's not just free to leave, it's or otherwise terminate otherwise terminate the encounter. And that language is important because what the court is saying there is, all right, so let's say you can't physically get up and leave, just ignore the officers. Ignore them. Disattend them. You have that right. You have that power. So exercise it. So this is now the formulation. And we end up at this formulation and with a particular way of thinking about constraint and limitation based on the undocumented case. So whether a reasonable person feels free to leave or terminate the encounter, the court doesn't take up the question of race and policing in none of these cases, doesn't think about race and immigration enforcement, certainly doesn't think about anything about implicit bias. And at the end of the day, we have a juridical regime that's constructed against the backdrop of people who feel over-policed, whether in the immigration enforcement context or outside of it, and none of their experience can be named. You cannot talk about it. It's just not a part of the jurisprudence. So with respect to the trigger question then, whether in fact you have a seizure, the undocumented case Delgado has played a really important role shaping the doctrine. Let's go back to Terry versus Ohio, because that's a space where you comfortably got your A, and let's do a little bit of nuance. So we've said that this case involves two moments that I want to emphasize and put into sharper relief now. So one is a stop and question. You approach someone, you stop them, and you question them. Another is stop and frisk. You approach someone, you pat them down for evidence. Justice Warren framed the question this way: whether it is always unreasonable for the police to seize a person and subject him to a limited search of weapons. Now, if ever there was a framing that invited a particular answer, this one is it. Always unreasonable, limited search, and for weapons? Who's going to say, it's always unreasonable to do that? And indeed, that's where the court lands. But I emphasize this framing as well for another reason, because it tells us, and the court is clear about this, that what the court is deciding is a question about stop and frisk. It is saying that you need reasonable suspicion to believe that someone is armed and dangerous to stop and frisk them. And in the context of articulating that rule, Justice Warren is at pains to say, this is a limited exception, we've got to do it, we don't want police officers to engage people and assume the risk of the bullet. This is just something we must do. It makes sense for us to do. The absence of probable cause cannot mean that police officers can't do this. That's his argument. He does not decide anything about stop and question. So one could take the view that, look, if it's stop and question, and you don't have a concern about your safety, you don't have a concern about armed and dangerousness, then probable cause. Go back to the default of probable cause. That's what one could imagine as the doctrinal terrain. Enter Brignone Ponce. So this is another immigration enforcement case. So this case involves roving patrols, so-called. So what's happening now is the Border Patrol, they're driving in the interior, and they're stopping people to investigate whether the driver is undocumented or the driver is transporting undocumented people. So in the context of this case, the court says reasonable suspicion is enough to justify the stop. This is the first case that applies reasonable suspicion to a stop moment unconcerned about armed and dangerousness. It's an immigration enforcement case that does that work. It is Brignone Ponce, A. B, in the context of that ruling, the court says apparent Mexican ancestry, that should be a M, apparent Mexican ancestry may be a factor in determining whether or not someone is undocumented. And finally, in concluding that apparent Mexican ancestry may be a factor, the court doesn't engage with this doctrine. Name that doctrine. See, my student shouted out, equal protection. So what do you do if you take race into account? What regime is triggered? Strict scrutiny. Is it triggered in this case? No. The court explicitly says apparent Mexican identity, apparent Mexican ancestry can be a factor in determining whether someone is undocumented, no reference to strict scrutiny. And you could say, well, Devon, this is relatively early in the trajectory of equal protection discourse. Fair enough. Noem versus Perdomo. This has been in the papers. You might even have read the opinion. It's another case that involves immigration enforcement. This time, we're talking about enforcement at particular locations, such as car washes, and the question becomes, what do we make of this, doctrinally speaking? There's no dispute that you have a seizure in the context of this case. It's not a Delgado moment. It's about what satisfies these seizures. And here's what Justice Kavanaugh says. Those factors that are listed, which is job-seeking location, type of work, Spanish, accent English, apparent race or ethnicity, those can give rise to reasonable suspicion. And he reproduces the line again that you can take apparent race into account in determining whether or not someone's undocumented. And he says nothing about strict scrutiny. I mean, if you read current equal protection jurisprudence, I mean, there is just this waxing on about what it means to take race into account in the context of voting rights cases or affirmative action cases or employment discrimination cases, and we can't do it because the sky's going to fall down and kill us. All right, I've been a little hyperbolic. But you know what I mean. You've read the cases. There isn't even a hint of a possibility that you might need to justify this under the Equal Protection Clause. Not even a hint. So naturalizes the idea that we're going to use race as a basis for identity in the immigration context that you can say this last year and not go to strict scrutiny. I mean, this is just shocking. You don't look shocked. This is shocking. And it's fundamentally doctrinally inconsistent, is the other part. Enter Justice Sotomayor. Now, what's different about their listing of the factors? Sorry? She puts apparent race at the top. I mean, this is literally the order in which they appear in their opinion. This is not accidental. Justice Kavanaugh is trying to say, it's not really about race. Sotomayor says, it is, and I'm going to stop there. The only other thing I want to say here, and I don't have time to go into it, both of these articulations are decidedly thin with respect to how they think about race. Race has never been just about physical embodiment. Race has been about markers of disadvantage. So precisely because you might be physically embodied in a particular way, you live over there. Precisely because you might be physically embodied in a particular kind of way, you do that kind of work. So it's not the case then that 1, 2, 3 in Kavanaugh's analysis are somehow not raced. If you know where someone lives, their zip code, you can say something about their race. It's not the case that everyone with my skin color is black, but it's a pretty good starting point for thinking about what my race might be. It's the same thing. And you can parcel that out by just thinking about how Jim Crow operated. It policed not just bodies, but domains. It policed not just domains, but the kind of work you could do. So when a person is working at a particular location, that's because of racial stratification. So it's not like race only appears in the analysis at number 4. So people who are litigating this case ought to be thinking about the degree to which, even assuming that Brignone Ponce is saying you can take race into account, but that cannot be the only factor, should be saying 1 through 4 is the only factor. It's only race that's being taken into account, but one needs to have a robust conception of race. One needs to think about race as social construction. I've already done way too much theoretical work, so I'm not going to do that one for you today. Instead, I'm going to switch it up one more time before inviting you to talk, which is to talk about Wren versus United States. So to talk about this case, we'll tell the story of 2 law professors. That's Barry Freeman, the other one is myself. And to unpack this story with some specificity, we have to, reveal that one of us is black and one of us is white, and I am the black guy. You realize that? So the point is this. So a cop sees both of us driving down the road. I'm in the black car, Barry's in the white car. Now I go too far, I'm racializing cars. And so the cop decides to stop, again, the black car. The cop has probable cause to believe that we both committed a traffic infraction. There's no dispute about that, okay? The cop stops me, not Barry. And I want to say that cannot be consistent with the Fourth Amendment because you've used race to stop me. The Supreme Court, in a unanimous decision, says, yes, they can do that, consistent with the Fourth Amendment. A unanimous opinion. To be clear, we're stipulating the officer's decision to stop me is based on race. The court says, so what? They have probable cause. So not a problem under the Fourth Amendment. A constitutional provision that says we have a right to be free from unreasonable searches and seizures. If the officer has probable cause to stop me for a traffic infraction and then piles race onto it, that is a reasonable seizure under the Fourth Amendment. Again, don't look shocked enough. I'm describing the black letter law. That's what the law is. And it's another moment when we have to ask, how do you get there without more contestation? So that's Wren versus United States. And the reason I put that in sharp relief is because you cannot drive your car and not commit a traffic infraction. I hope you know that. Which means that effectively it's just driving a car and a race-based stop. That's basically what that means. The undocumented case here, and this is where I'll close, is United States versus Martinez-Fuerte. So this case involves a checkpoint. And the checkpoint is a seizure. There's no dispute about that. And the checkpoint has 2 moments. So one moment is you're driving through and you're slowing down, and that's a seizure. And the other moment is you refer to this secondary area, and that's a seizure. The court has said, even if we stipulate that both of those decisions to slow you down and move you to the secondary area is based entirely on apparent Mexican ancestry, so what? That is constitutional. And it relates to the point I made about Wren. Wren is saying, so long as you have probable cause, you can take race into account. Here, you don't need any justification to stop people at these checkpoints. So you got your justification, which is nothing. So when you have what you need, which in this case is nothing, you can pile race onto it. When you have what you need in the Wren context, which is probable cause, you can pile race onto it. So the story I'm trying to tell then is really a twofold story. One, let's think structurally about this matter, both at the broad theoretical level and also with respect to legal doctrine, just to understand what the dynamics are. I'm not saying that we will agree with respect to what to do about it. We can fight about it, but we shouldn't be fighting about whether or not a cop is good or bad. And second, we should understand that immigration enforcement is not over here in a special place, just shaping immigration enforcement. It's shaping as well what happens in the interior. And if you haven't already bought this book, shame on you, because I told you to get it. So just buy it, and I'll stop there and take any questions or comments you might have for a few minutes. So when I stop, any comments or questions? Yeah.
I think your dramatic presentation is brilliant. I think you're slanting the thing a little bit because I think what we're talking about structurally is the balance of power between government to do things and intrude upon your rights, and for you to be protected in your rights and not have that intrusion. And I find the presentation a little bit overweighted in not describing the necessity for law enforcement to exercise certain powers. So we're trying to describe, 21st century civilized society, what should the power of the government be to look at you, to investigate. And with a number of the cases you were talking about seizure, and I was interested why you were talking about seizure, not search. The bus and all the rest, these were searches, unreasonable searches, not so much seizures.
So just interrupt you there. So that is inaccurate. So the issue in these cases is whether you have an unreasonable seizure, because if you have an unreasonable seizure, anything that happens after that is problematic. So the search is problematic. We don't even have to get to the search. So the argument in these cases is you need to suppress the evidence you found by going into my bag because you shouldn't have seized me. So it's the seizure question that is crucial. So just as a matter of doctrine, just know that your formulation is not right.
So you're saying that the just questioning him in the bus was a seizure, or was a seizure when they took his bag?
So it was not a seizure in the case, which is why everything was okay. So the court says Bostic was not a moment in which the person was seized, A, and then he consented to the search of his bag, so it was all good. Had the court ruled that it was a seizure without justification, then he could not have consented. So everything turns on the seizure, so it's really important that you understand that. So these cases are in the first instance trying to figure out, let's think through the first moment of contact. The first moment of contact implicates the seizure question, and that's why the court goes there. So that is the statement of the law. The second thing that you say, these cases are fundamentally about balancing in exactly the way that you describe. And the question is whether or not we should balance in a way that permits race-based decision-making. We've said that that's bad. Since Brown versus Board of Education, we said that is normatively bad. So should we balance interests in a way that says you can stop someone on the basis of race? I would have thought that was an easy no.
Well, if you go the extra step and say profiling, to what extent would you say profiling is permitted?
We can have a long debate about what you might mean by profiling, etc. I want to focus on what I said in this presentation and your concerns about balancing. And I just throw back at you. If I'm saying that the Supreme Court lands in a place that says, if you're probable cause to stop someone for a traffic infraction, you can take race into account, my hope is that people would say, that's not a satisfying doctrinal outcome. My hope is that people would say, we adopt the notion that someone's identity should not be a marker of anything, certainly not a marker of illegality, in the way that it functions with respect to immigration enforcement. And the final thing I will say, if the court is going to take that view, then it needs to be way more consistent. It can't say, let's shut down the fact that we're going to really critically look at it when we're trying to adopt policies to help people, right, which you say are problematic, and then when we want to lock them up and deport them, we're going to allow you to take it into account. That is the asymmetry that exists. I mean, this is not me politically saying anything. That's just how the doctrine works. I showed you these cases, the ones in which the court is taking race into account. There's no dispute about that. And the ones in which the court is not going to strict scrutiny. That's just descriptively accurate. And I'm trying to make sense of that over and against the context in which the court does go to strict scrutiny, and I can't get my head around it. So it's that inconsistency that we're not balancing things in the right way. Other comments? Yeah.
Has the strict scrutiny question ever been briefed and fully presented to the court?
So I don't think these issues have been always framed in the way that I might want, candidly. But I don't want to say that because our litigators are furious and doing terrific things. So, and I've not. I've had one set of conversations with some litigators who are thinking about some of this stuff. So to put it this way, the story about whether it would appear remains to be fully told. Yeah.
I wondered if you're talking about federal constitutional law.
Yeah.
I practice in New York State, and New York State has, of course, its own delightfully rococo search and seizure jurisprudence with 4 different layers of decay.
Yeah.
So I wonder if you would talk to, have you observed, or is there a doctrine at the state level that takes these concerns into account, or are there promising avenues at the state level to pursue these type of ideas?
Yes, I mean, so it's always helpful to remind ourselves that the federal constitutional stuff is just the floor. And so one can indeed imagine greater protections, including along the axis that I've just described. And some states are doing precisely that. So there's one doctrine, for example, in Fourth Amendment jurisprudence that goes, although you're free to leave and terminate encounter, so an officer doesn't have any reason to think you've done anything wrong, you're free to leave, ostensibly. But if you run, and you're in a quote-unquote high crime area, then you're not leaving on terms that we think you should leave, so now we have reasonable suspicion. Again, doctrine, I'm not making up. That is Illinois versus Wardlow, where the court basically says that running in a high crime area equals reasonable suspicion. Now, a case in Massachusetts, whose name now escapes me, basically says, we're not going to have that as a default. Because if it's the case that you've been subject to repeated police interactions, or those interactions have not been particularly comfortable and indeed potentially dangerous, then the reasons that you might want to avoid the police. So we're not going to take the position ex ante, a priori, that to flee from the police means that the government can draw an adverse inference. So that's just one example. But it's absolutely the case that the action with respect to constraints on police power in terms of extending greater protection has to be at the domain of the state, given where the court has been for quite some time. So there's a hand over here somewhere. Yeah.
Can I ask, so the thing that's blowing my mind at the moment is the checkpoint. No PC, no nothing.
No nothing, yes.
Okay. And then we're going to get to, if you're speaking Spanish, you're going over there.
Yeah, yeah. So it's not just, so the 2 levels, again, fully discretionary with respect to what you can do. The court has made clear that if you want to contest all of this, then you can make an argument that the decisions about where to put these things are problematic, that somehow the government failed in its due diligence in deciding where to put a checkpoint. That's an argument that you can make. But to point to some individual decision about stopping me, it's just not going to work because, again, the government needs nothing because of how interests are balanced. And I'll take one more question and then we'll stop.
I just want to clear up, the Forte case, that wasn't a border search, that wasn't a border checkpoint coming into the United States, correct?
No, it's not.
Oh, okay.
Absolutely.
That's a different.
That's a whole different thing.
Yeah, I just want to make sure.
Absolutely.
It wasn't clear from those.
No, this is, so you have immigration enforcement stuff in the interior.
Okay.
If you're at the border, then the government has even greater authority. It's just like you have sobriety checkpoints. Does the government need any justification to stop you at sobriety checkpoints? No, it's the same idea. They can just stop you, you don't need anything. So immigration checkpoints run the same way. And the final thing I will say, and then I will really let you go, is that part of these cases are about the idea that the government's interests are regulatory, special needsy, and not necessarily about hardcore investigation. So it's a very, very hard line to ultimately manage, but it certainly does work in these cases. So thank you all very much for coming. Welcome home and enjoy the rest of the day.